Again. So today we will be starting with the second part of the boilerplate clauses. Uh, this session is meant for some of the important boilerplate clauses which are otherwise not very common, but they are very essential to know about. So first one is the bank guarantee. So, if you remember, we discussed this earlier also. A bank guarantee is basically a guarantee given by a bank uh, to the customer or the owner of the project on behalf of the contractor. Now, this contract of bank guarantee is between the bank and the owner. So it's an independent contract from the underlying contract, and it will have an independent term, it will have independent obligations of the bank, and usually it can be a irrevocable bank guarantee, and once invoked by the owner or the beneficiary, the bank is obliged to pay without any objections. However, certain conditions have to be fulfilled, like the manner in which the bank guarantee is required to be invoked. So there must be a written request for invoking the bank guarantee, a letter from the owner to the bank, and some other conditions like it has to be made within certain time frame. So there may be a time limitation by that. The bank guarantee is used as a security for performance or payment and also as a risk mitigation tool. It can either be a revocable one or irrevocable one. It can be a conditional bank guarantee. So, like fulfillment of certain conditions have to be met, then only bank guarantee is enforceable, or it can be an unconditional one. So, just by invoking the bank guarantee, the owner can get the benefit of the bank guarantee. It is always delinked from the main contract, and the parties involved are the bank and the owner. There can also be an option of renewal or revision. So, for example, if the original project is completed, then there is a warranty period. Then there can be reduction in the value. There can be an extension of the term of the bank guarantee. Then comes the parent company guarantee, which is like a bank guarantee, but it is given by the parent company of the contractor, and it is also known as corporate guarantee. There are certain RBI regulations which restrict the amount or quantum of parent company guarantee that can be given by the parent organization. It is also used as a security or risk mitigation tool, and it is dependent on the financial credibility of the guarantor, that is the parent company. And there is an insolvency law angle also. So let's say if the parent becomes insolvent, then what will happen? So in that case, the parent company is unable to pay the debt, then the owner can ask the contractor to give a fresh bank guarantee or a corporate guarantee. Then there is a disclaimer clause. Disclaimer is basically waiving of certain types of warranties or liabilities. So usually under Indian law, the liabilities like consequential losses, uh, like loss of profit, these are excluded by law. But in certain civil law countries like Germany or France or other European countries, these may have to be specifically excluded under contract. So they are uh, clubbed with the warranty clause, and specific exclusion of certain types of warranties or liabilities have to be specifically included in the contract. There are two types. One is a general kind and one is a specific kind. So general means a general exclusion of liabilities like what is provided under Indian law, and specific ones will be like specific to certain warranties given by the contractor. So contractor may say that he is excluding the warranty for any third party breach because of which the owner may suffer losses. Uh, some liabilities like liabilities due to fraud or gross negligence or death, they cannot be excluded under law. So this may or may not be present in the contract, but it is understood that liabilities arising of death or liabilities arising of law, breach of law, these cannot be excluded. Next is the indemnity clause. This is very important provision in any contract. Uh, this is most negotiated, and uh, parties will get into extensive discussions on this particular clause. There are two parties involved. One is the party who is indemnifying, usually the contractor, and the indemnified, usually the owner. But in some circumstances, it can be other way around. For example, if the contractor is providing, let's say, in case of software licensing, if the contractor is providing a software, then there may be an indemnity, IPR indemnity. What it protects is basically the interest of the indemnified party. So let's say if there is a contract between the owner and the contractor, and the owner wants that the uh, whatever supplies the contractor is providing is as per the specifications which the supplier has given, or let's say as per the designs provided by the contractor, then the contractor will indemnify the owner for any defects in the specification, but not in the any defects in the design, because it was provided by the owner. So uh, in such cases, the non-indemnification of the design part will be considered as a exclusion to the indemnity. So there is a carve out in the indemnity, that indemnity is provided for the specification. So the parts supplied will be as per the specification, but the carve out will be that in case that part is defective in design, which was provided by the owner, then the indemnity will not be applicable. Any indemnity clause has to be enforced only through courts. It cannot be a demand made by one party on the other. It has to be proved that the indemnity clause has triggered and the owner has suffered the loss as per the clause of the indemnity. It has a very wide scope, because in damages claims, at least in Indian law, the damages are allowed only if they are proved and only to the extent the loss is suffered by a party. But in case of an indemnity, the other than damages, any other losses, or let's say if there is any extra cost incurred by the owner, that can also be covered under the indemnity. Indemnity is usually excluded and is in addition to the limitation of liability clause. Next is the IPR clause. So there are different types of IPR which we know of, like copyright, trademark, design. So we have to understand what type of IPR protection has to be included. For example, in case a software is being provided, then it can be a copyright that can be covered, which can be limited as to the scope. For example, the copyright is being given only for the software if it is being used in a certain system, or let's say if it is being used within certain premises or on certain PCs. uh, in case of, let's say, a trademark, there can be a limitation that the trademark has to be applied on the goods which are being sold within certain jurisdiction only, and not outside those jurisdictions. Then there can be an IPR indemnity clause. So just like an indemnity, general indemnity, it can be a specific IPR indemnity. So if it is my trademark that I have given to a client, then I have to warrant that my trademark is not in breach of any other third party's trademark. So they can freely use my trademark under license. So in that case, I will be giving an indemnity to that regard. The license that we are giving under the IPR can be restricted or can be very wide under scope. So we'll see some examples later on. Insurance is another important clause. So it is again a risk mitigation tool. What we have to remember is that insurance coverage is being provided by a third party insurance service provider. So if a client is asking a contractor to have, let's say, erection all risk insurance in case of a construction contract, then we have to understand what is the coverage of that insurance and what are the exclusions, in which cases the insurance company will not honor, who are the beneficiaries of that insurance cover. So usually owner will ask the contractor to include the owner as a beneficiary. And we have to remember that the insurance is just a mitigation tool, but in certain circumstances not 100% of the claims will be covered. So we have to ensure that in case of any additional claim, it is also covered under the indemnity, which is rejected by the insurance company. Next is the liability clause or limitation of liability clause. This is used by the contractor to cap their liability under the contract. It is again a widely negotiated clause after the indemnity. The determination of cap is based on the type of industry or type of service or goods or type of transaction. So, in case there is a capping of liability, then usually the confidentiality clause, breach of law, or indemnity clauses, these are excluded from the liability cap. Now, if I say I am performing a service for a client and I am getting, let's say, $5,000 per month. So I may limit my cap to the last 3 months revenue that I get from the client, irrespective of the client's claims. So anything over and above that, I will not be liable for that, except and unless it falls also under a breach of confidentiality or breach of indemnity or breach of IPR and all that. So these exclusions, other than the exclusions of indemnity, confidentiality, and all that, the liability cap will be up to a certain extent, which is negotiated and agreed by the parties. Next is liquidated damages. Just like damages, we have liquidated damages. So some are unliquidated. So in US, you may have heard that the damages awarded in case of any tort claim is very high, unlike India. But in case of Indian Contract Act, it is limited. So every damage has to be proved and it has to be reasonable in scope. And there can be two situations. One can be a damages which has to be proved and then that will be awarded by the court, or it can be a liquidated damages, which is basically a predetermined amount of damage that the parties will say that that is the estimated damage that they foresee, because the calculation of damages is difficult. So one example is delay in performance. So it's known as delay liquidated damages. In that case, if the project is not completed by certain time, the given time, then the owner will levy a liquidated damages at the rate of, let's say, 1% for per week delay, going up to 10% of delay. So 10% of contract price. So that's the maximum capping. So it has to be reasonable and it has to be a predetermined estimate. It is not required to be proved, but at least it has to be proved that the owner suffered damage. So proof, the basis of proof changes. It is also backed by bank guarantees. So there can be a liquidated damages bank guarantee. The liquidated damages and general damages are a little bit different. So we have to understand that difference. And in case we are asking general damages, we have to understand that this needs to be proved. In case of liquidated damages, it can be claimed. Of course, the other party will contest it, but there is a high chance of getting claim under a liquidated damages because it is easy to prove that delay on the part of contractor. So that is all in this lesson. So if you have any questions now, we can take that. Just a second. Is the screen visible now?
Yes, sir.
Okay. So this is a clause of bank guarantee for the advance payment. So uh, the clause says, uh, let's exclude the first part, except when the interest of UNDP so require. It is the UNDP will make no advance payment or contracts. Uh, let's read the second part. In the event that the proposer requires an advance payment upon contract signature, and if such request is duly accepted by UNDP, and said advance payment exceeds 20% of total proposal price or exceed the amount of USD 30,000, then UNDP shall require the proposer to submit a bank guarantee in the same amount as the advance payment. So, what exactly is required here is that only in case there is a advance payment requirement and UNDP is making that payment, then the proposer will have to give a bank guarantee, and that bank guarantee for the advance payment shall be in certain form as provided in section 10. So this type of clause is very unique to this particular contract, but it simply says that there is a requirement of bank guarantee from the proposer to the UNDP in case of advance payment. Now let's see another scenario. Yeah, this is the actual guarantee contract kind of. Now this clause says where ISR and supplier entered into certain agreement. Now the bank hereby irrevocably guarantee to ISR due, punctual, true, faithful, and satisfactory performance by supplier of all the obligation on its part contained in said agreement, including for the removal of doubt, warranty, and ancillary services as set out in the agreement, and undertake to be responsible and indemnify ISR for payment by supplier of all sums of money, losses, damages, costs, charges, and expenses that may become due or payable to ISR by or from supplier by reason or in consequence of the default of supplier in performance, execution, or perseverance of its said obligations, all in accordance with the provisions therein, that is the guarantee. So, what the bank is saying here is that in case of any obligations which is to be executed by the supplier towards the warranty, then the bank agrees to indemnify and pay those charges to ISR. Nevertheless, the total amount to be collected by ISR from us under this guarantee shall not exceed X amount. This guarantee is unconditional and shall not be revocable by notice or otherwise, and our liability hereunder shall not be impaired or discharged by any extension of time or variation or alteration made, given, conceded, or agreed under the said agreement. So basically, this is an unconditional guarantee, and irrespective of there is any change or extension of time or price variation or any other variation, it will not be affected. The guarantee shall remain in force and effect until and including day and month and year, and after such date it shall expire. So there is a limitation or date of this guarantee. In order to collect any amount under this guarantee, ISS shall not have to refer to supplier, shall not have to produce any judgment or other judicial document, shall not have to prove any breach, failure, or non-compliance on part of supplier or on the part of any person acting for it or on its behalf or its name, etc. Sorry about that. And a written demand by the DGM, Commerce, Economic and Finance of Israel Railway Limited, that is ISR, or by a person designated in writing by him, substantially in the following form shall be sufficient for all purposes of this guarantee. So basically, it is saying what is the manner of making the claim under this guarantee, and specifically shall be sufficient to collect any sum under this guarantee from us, and we shall pay such sum immediately upon such first demand by ISR. Then it goes on to say within inverted commas what exactly is the wording that has to be given to the bank. So for claiming this, what are the important clauses? One is that the guarantee is given by the bank to the beneficiary, that is ISR. Then it is limited by amount, that this the maximum claim cannot exceed X amount. Then that it is an unconditional one and cannot be revoked. Then it is limited by time, so all demands have to be made by certain time. Then the manner of making this, so basically they do not have to refer to the supplier, they do not have to produce any judgment, they do not have to prove any breach. They can just make a written demand either through their DGM or through any other person appointed, and make the demand in the following format. So once they do that, the bank has to pay. This is the fixed or kind of a standard language. So little bit variation here and there, but this is the irrevocable bank guarantee format in all cases. So these are the essential elements. If you're drafting a bank guarantee or you are reviewing a bank guarantee issued by a bank, you should look out for these clauses. Let's say an indemnity clause.
Yes, sir.
Okay, so the first one, limitation of liability. It says, in no event shall licensor or its licensors be liable to licensee or any third party for any general, special, indirect, incidental, or consequential damages. This is also covered under Indian law, including without limitation indirect, special, punitive, or exemplary damages for loss of business, loss of profit, business interruption, breach of security, or lost or damaged data. Arising damaged data or loss of data is usually covered where, let's say, you are providing a software or any mechanism by which data is provided. So let's say you're providing a hardware for storage of data, or you're providing a PC, and because of any defect in the PC or that hard disk, there is some loss of data. So you're not liable for that. That's the disclaimer or limitation of liability. Arising out of or connected in any way with this agreement, the licensed software or any services rendered by licensor, even if licensor has been advised of the possibility of such damages, excluding licensor's indemnification obligation. The total liability of licensor to licensee for all damages, losses, and causes of action, whether in contract, tort, including negligence or otherwise, shall not exceed the total fees paid by the licensee hereunder during the 12-month immediately preceding the event giving rise to liability. So this is very standard language. So first part is the exclusion of any consequential losses, damages, or indirect or special damages or incidental damages like loss of business or profit, breach of security, loss of data, etc. And which is even if there is an advice of the possibility of such damages, and it excludes the limitation excludes, however, the indemnity obligations, and it is capped to a certain extent, which is 12 months immediately preceding the event giving rise to liability. So this is the standard limitation of liability clause. The fees here is saying 12 months fees. Instead, it can be a amount, specific amount, or it can be a let's say fees paid in last 3 months immediately preceding the event, or let's say fees paid, let's say if there is a PO based ordering, then fees paid in the latest PO. So those kind of limitations can be there. So this one says the company and the subsidiaries are insured by insurers of recognized financial responsibility against such losses and risks in such amounts as are prudent and customary in the business in which company and the subsidiaries are engaged, including but not limited to directors and officers insurance coverage at least equal to aggregate subscription amount. Neither the company nor any subsidiary has any reason to believe that it will not be able to renew its existing insurance coverage as and when such coverage expires, or obtain similar coverage from similar insurers as may be necessary to continue its business without a significant increase in cost. So this is not much of a clause for insurance. This is just a specific clause for a specific situation. Let's see if you can find any other one. Yeah. So this one says Let's see something more. Which can be used. Yeah, let's see this one. The company carries property liability, workers' compensation, and such other type of insurance pursuant to the insurance policies listed and briefly described in company disclosure schedules, the insurance policies. The insurance policies are all of insurance policies relating to business of company. All of the insurance policies are issued by insurers of recognized responsibility and to the best of knowledge of company are valid and enforceable policies except as may be limited by applicable bankruptcy, insolvency or similar laws affecting creditors' rights generally or availability of equitable remedies. All insurance policies shall be maintained in force without interruption up to and including the closing date. So, this is a transaction involving acquiring of a company. So the buyer is invoking this clause against the seller, saying that they are maintaining the insurance policies as listed in the schedule, disclosure of the insurance. The true and complete and correct copies of all insurance policies have been provided or made available to acquirer. Neither the company nor any stockholder has received any notice or other communication from any issuer of insurance policy cancelling such policy, materially increasing or any deductibles or retained amounts thereunder, or materially increasing the annual other premiums payable thereunder, and to the actual knowledge of company, no such cancellation or increase of deductible retainages or premiums is threatened. There are no outstanding claims, settlements, or premiums owed against any insurance policy, or the company has given all notices or has presented all potential or actual claims under any insurance policy in due and timely fashion. Company disclosure schedules also set forth a list of all claims under insurance policy in excess of 10,000 per occurrence filed by the company during the immediately preceding 3-year period. So, this is a specific type of clause for a transaction where a party is buying a company and the seller is has disclosed certain insurance policies, and the buyer is getting a warranty kind of clause from them that up to the closing date they will maintain these insurance policies. There are no claims which are not known to them, and if there are any claims then they are listed if they are in excess of $10,000 per occurrence in last 3 financial years. So this type of clause is very unique. You may not find it in standard ones, except in, let's say, EPC contracts. You may find insurance clauses which say that the contractor is required to maintain insurance for risk, construction related risk, or for payment of any employee related obligations or for accidents. So those kind of insurance covers have to be maintained. The copies needs to be provided to the owner, and they have to be renewed, and the money or premium has to be paid by the contractor. And in case they are not doing that, then the owner may secure such insurance on behalf of contractor and deduct the payment from the payment payable to the contractor. So these kind of insurance clauses can be there. Let's see if we missed anything else. Liquidated damages clause. Let's see. In the event of delay in project completion, the performing party shall pay liquidated damages to the owner in the amount of X per day per week or X
Yes, sir,
percent
it's
of
visible.
total contract price per day per week. The parties agree that the liquidated damages as described in the agreement are genuine estimate of the owner's foreseeable damages and are the owner's sole remedy for such delay. Delays caused by force majeure events or by actions of owner shall not constitute a delay resulting in payment of liquidated damages. So the first part says what is the liquidated damages amount payable. So either it can be an amount per day per week or it can be X percent of the contract price per day per week. There can also be a capping. up to 10% or up to 5%. And then there can be a clause which says that the it is a genuine estimate of the foreseeable damage and the sole remedy for such delay. And there is an exclusion that delays due to force majeure or actions of owner will not be a condition for payment of liquidated damages. So this is quite simplified clause, but this kind of clause is generally available in EPC contracts. Uh, so any questions so far on any of the clauses?
I have a question.
Yeah,
This is for guarantee clause. Okay, what kind of agreement should have guarantee clause?
you mean payment or bank guarantee, or you mean just the guarantee?
Bank guarantee and the guarantee both.
Okay, so general guarantee, if you know the Sale of Goods Act, now nobody gives guarantee. Okay, so in case of sale, they only provide a warranty, and the difference in warranty and guarantee is well understood hopefully by everyone. Guarantee is like a condition, and warranty is a contract clause, and breach of which results in damages. So, if you are selling a product to a customer, you will provide a warranty on that product, and usually the terms will be contained in a warranty card for that product. It will say that for a certain period after the sale, we will repair or provide a replacement in case of any defect in the product. That's the warranty clause. The bank guarantee is very different from the general guarantee. It's kind of a contract between bank and the beneficiary, which can be an owner. So in EPC contracts, let's say there is a performance guarantee, or let's say timely completion kind of requirement on the part of contractor, and contractor delays, and because of contractors delay, the project is delayed, and the owner suffers any loss because they also have back to back obligation, let's say, to their own customers. So in that case, they will say that the contractor is required to give a bank guarantee. This bank guarantee is issued by a third party bank, which undertakes that they will make the payment of the specified amount under the bank guarantee to the owner on demand without any protest and without any reference of the contractor, or without any need to prove a breach of contract or anything. So just by making the demand, the owner will get the payment from the bank. So this bank guarantee is a distinct contract with the main underlying contract. So we have to understand that a breach of the main contract does not mean breach of bank guarantee, or a breach of bank guarantee does not mean a breach of main contract. So if there is a breach of bank guarantee, then it can either be bank's refusal to honor the bank guarantee because of some reasons, or it can be a breach of guarantee, let's say if the demand is not made within the time frame of the validity of the bank guarantee. So those kind of situations can be there. The guarantee clause, on the other hand, now is no longer part of the contracts, and instead of guarantee, the warranty clause is also there. So, for example, let's say if there is a service contract, service agreement, then there will be certain warranties by the service provider, and there will be some exclusions to those warranties. So, for example, if I am a IT service provider, so I will say I will provide you certain IT services, and I warrant that these will be as per the requirements or as per the needs which the software or the services club with. So, but the exclusion will be like my warranty will not apply because of non-availability of, let's say, another tool, or let's say because of failure of power or failure of internet services. So if those kind of things are required for performance of the service, then because of absence of those, my warranty will not be applicable. So that kind of clause can be there in a contract. Now, in the lesson PDF that I have shared, there is some sample bank guarantee. You can just click on these links and go to them. Then there is, which we already discussed, some sample clauses on the disclaimer, indemnity, and IPR indemnity. So these are standard clauses. I have kept this lesson very brief because this is not something that can be covered or captured in a lesson. Uh, it comes from lot of understanding, lot of negotiation, practicing, and there can be different situations. So these are some samples which you can refer to, but definitely they are not the everything. So as and when you practice and you read more about these, you will understand more about these clauses.
Okay, another question I have, sir,
Hmm, hmm,
that is regarding indemnity. So
hmm,
let's say if we are negotiating a IT contract,
hmm,
okay, an IT services contract, and it's a service, um, and and I am the service provider.
hmm, hmm.
So how will I negotiate indemnity clause? Because generally the opposite party definitely they want to cover everything. They want to indemnify everything.
Hmm.
So how will I safeguard my interest?
Okay, so I'll give you my experience. Um, there are two kinds of remedies that the client can get. One is damages, and one is indemnity. So indemnity is a higher relief that the client can get. So what I will usually do is I will carve out anything out of the indemnity for which damages is the right relief. So for example, I will, if I'm a software service provider or let's say IT service provider, then in that case, except for IPR indemnity, I will argue that everything else is covered by the warranty clause. And usually in IT services, there is no warranty given for the service. That's a very unique element of the IT services because they will provide a disclaimer in the service contract that uh, the only relief that I am going to give you as a service provider is that in case of any issues that you face, I will handle those issues certain within certain time frame. So they have a separate service level agreement for that. So they will say if it is a very critical issue, I will attend to it within 1 hour or 2 hours. If it is a moderate issue, I'll revert within 24 hours. It is a general issue, then I will revert within, let's say, 3 days or 2 working days. If it is requiring some software patching or let's say upgrade, then I will give you that. But I will say that I am providing you my software as a service or a software on as is basis without any warranties. I will also provide disclaimers like whatever services I am giving you is subject to availability of third party services like electricity or internet availability. So my services are not guaranteed in case of there is any non-availability of power or non-availability of uh, internet services. Those kind of
Oh,
exclusions can be there. But I will definitely give the IPR indemnity. So if I am giving you an software as a service, then I will say that my in case of a third party claim of IPR against my software, then I will uh, indemnify you in case of any claims, and it can be again limited by way of saying that in case of a third party claim, I will secure a right so that you can continue to use the software. So let's say if I have to pay a license fee as a service provider, then I will pay those license fee to the third party or I will settle that claim with the third party because it's very normal to have such claims from third parties in software industry. So I will get those settlements or I will get those licenses so that my client can continue to use the software.
Okay, so basically, you mean to say, being a service provider, I should indemnify for third party claims.
Third party IPR indemnity claims.
Okay, only the IPR indemnity,
Yeah,
apart
if
from
you are
that.
a IPR service provider, if you are providing any service which is in the
Mm-hmm.
IT industry,
Mm-hmm.
then you should try to limit it for IT related IPR. And you should not agree to a indemnity for general breach of contract, because for breach of contract damages are the standard remedy. So, in case it is argued that you need an indemnity from breach of contract, then you
Mm-hmm.
can argue back that the damage will be the sufficient remedy for that. It depends on the level that your client is and you are at. So, of course, if it is very reputed client, you don't want to lose business, then you may agree to such an indemnity also.
Mm-hmm.
So, what is your negotiation power that will generally determine what you can agree to or what you cannot?
Okay, and another thing, is it a good idea to negotiate for like the actual damages,
No. See,
proportionate damages?
no, no, because the burden of proving the damage is on the party who is claiming that damage. Okay.
Mm-hmm.
And
Okay.
in Indian context, it is very, very difficult to prove damages because it's not a very simple case that you have issued a check and the check bounced and you are getting things proceeded under Negotiable Instrument Act. In case of
No, but
any,
as a,
yeah.
if I'm the service provider, then from my point of view,
Hmm.
if I'm the service provider, then the burden of proof will be on the other party, right?
Right. So client will have to show that they suffered any damage, and those damage cannot be unreasonable. So even if they are successful in claiming damages, it has to be proved what those damages were. And whatever those damages were, it cannot be unreasonable. So, for
Yeah.
example, let's
So.
say if you are getting a revenue of 1 lakh rupees per month, okay,
Mhm.
and you have a 12 lakhs annual contract with the client. So you can use a limitation of liability clause to cap your liability for damages cases. So you can say my limitation of liability will be only of last 3 months revenue that I'm getting from the client. You can start with that. You can agree to a maximum cap of 1 year's revenue if it is a continuing contract. So in any case, if the loss is more than those that particular limitation of liability number, then they will not get that relief under the damages provision.
Mhm.
So basically, mitigating the risk as a service provider, you will have to use not only the damages provision but also the indemnity provision, also the limitation of liability clause.
Yeah. So in that case, so the proportionate liability will be, as a service provider, will be a good fit, right? Because then the burden will be on the other party because they had to prove it, like all the
See, it is
damages and all.
very, very unlikely that dispute will be there in case of IT services. Even if a dispute is there, it goes to court, then they have to show that what kind of damages they suffered. And proving those damages is quite difficult because more often the people who are behind a contract they change very frequently, or the documentation is not proper, or some kind of proving the actual service, IT service, performance of that service, that it was not performed is very difficult. Because as a service provider, IT service provider, what you are doing, let's say you are supposed to, let's say, create a software, or let's say you're supposed to maintain a software for a particular period, then your obligation as a service provider will be like, I will provide an on-site support. So for let's say 2 hours in a week, my person will go at your site at client side, and they will remedy any issues or defects or any challenges faced by the client. Now, if your person has gone for those 2 hours during that period and they have tried to resolve it, and if you have a clause which says that these services on as is basis and there is no warranty because of dependence on third party software, and there is no warranty because of non availability of internet, or let's say there is no warranty if the client has used the service or the software in a manner which it was not intended, or if they have modified the software. So those cases are the exclusions. So you can take cover under those clauses. So actual dispute will be very unlikely. But yes, if it is a reputed client that you want to retain, then you may agree to some kind of hitback. So practicality takes over from instead of contract clauses. Indian scenario is little different.
Mm-hmm. Okay. Thank you.
Any other questions, anyone? Okay. So basically, these are some of the important boilerplate clauses that we discussed. There are other general clauses also, which we'll see in next classes. Uh, but if we remember, we have to focus more on the scope, price, term, uh, then the payment terms, and any warranties. And in the boilerplate, we have to look for indemnity or IPR indemnity or warranties or limitation of liability, uh, and also dispute resolution clauses like jurisdiction. So, depending on the type of client, the nature of transaction, the negotiation power of the parties, you may get them to agree to some of the clauses, you may forego some of the clauses. So it depends on the overall contract negotiation, not just one part of it. So as a contract drafter, you should not get stuck on things because business will not like it. Business will want you to close the contract ASAP. So as a contract drafter, your idea should be to get to a common ground with the other side as fast as possible. So you'll have to weigh which clauses to argue on, which clauses to forego. So that kind of understanding has to be built. It comes from experience, of course, and some guidance can also be taken from the business side because it is business who is requiring that contract. And as a contract drafter, our role is as of a facilitator. But having said that, you also have to take responsibility for whatever you are writing. So you have to make the business understand the risk that if they are agreeing to this clause, what will happen in case anything goes wrong. So let's say if there is a dispute resolution clause which talks of arbitration, and arbitration is at a venue which is at the client's location, not at your location. So what will happen is that for that arbitration, your team will have to travel. You will have to hire maybe a lawyer from that location, or if you're hiring from your location, then that lawyer will have to travel. Then they will also charge you for that. So think from that perspective also. So if you're agreeing to something which your client is insisting on, which is not in your favor, then there are repercussions to that. If let's say you're agreeing to a limitation of liability where the entire contract value is 1 CR in a year, and you are agreeing to 100% of limitation of liability of last 1 year's revenue, then 1 CR is a very big amount. So you have to make the business understand that agreeing to this capping is not in their interest. Then sometimes business can also take over and they can get the other side to agree to a lower number. So it's kind of a relationship that you have to have with your business team. So understanding the business, having a relationship with your business team so that you understand the business and they understand the legal and commercial risk. So your role as a facilitator is more in picture rather than having a final stand that no, I know the best of the law, I am well read and I know the risks, so I will not advise you to go ahead. Don't have that kind of rigidity in your approach. Always be very, very flexible because ultimately companies are required to do business and you have to weigh out the risks. So understand the risk and then proceed. And if there is a risk, watch out for those risks. If there is any adverse experience you may get because of some contract going not in your favor at later date, then try to take learnings from that failure and incorporate and improve your contracts subsequently. So it's a learning exercise day in, day out. There are many judgments which are coming every day in different jurisdictions on contracts. So it will help if you read the latest judgments on different types of disputes or contracts or contract clauses. So you are more aware how to handle that. So Mondak and Lexology is always a good source to read about different types of clauses, what is latest development in those areas. Another area is the insolvency laws, which is affecting the contracts. So, in case of bank guarantees, especially what will be the impact of an insolvent client or insolvent contractor? So, those situations have to be thought of because bank guarantees are distinct from the corporate guarantees or the personal guarantees of the directors. So, you think from that perspective also. So, broaden your knowledge, broaden your thinking, read, read, read. That's the main idea before you get into actual contract drafting. Any other question? Anyone?
So you mentioned two sources. One was Lexology, and then the what was the name of other one?
Mondak, Mondaq.
Okay, sir.
In both, you have to create an account, free account, and because after some free, I mean, articles, you will have to log in. So it's better if you have an account. You can also have a subscription in the area of your interest. So let's say if you're interested in insolvency laws or developments in insolvency laws, then you can have a subscription on that website also. So you'll get periodic emails, or you can just have a look every day. Better to have a subscription so that you get summarized information in your emails, and every morning you get a update. Also, try to check out some law firm websites, some Indian ones and foreign ones also, reputed names. So they also have this kind of subscription. So you can get their periodic articles.